This is Michael Popok, and it's time for Legal AF After Dark. The United States Supreme Court has jumped in with both feet and both hands into all things Jan 6 defendants and Donald Trump with a new oral argument that just got heard this week, in which they're considering whether to strip away from 300 Jan 6 defendants, basically opening the floodgates, strip away a charge that was made by the prosecutors for criminal obstruction of an official proceeding, because some on the Supreme Court seem to think that it only applies if you take the electoral certificates in your hands during Jan 6 and you rip them up. That's the only type of interference that obstruction of justice means under this particular statute. Is that true? Is that how the Supreme Court's ultimately going to rule? And what does it mean for the fact that 2 of the 4 counts against Donald Trump in the DC election interference case, which we hope to get up and running after a April 25th oral argument on immunity, what does it mean for that if he loses those 2 counts? Does he lose those 2 counts because of a Supreme Court ruling that that count was improperly charged? And even if it doesn't automatically apply to Donald Trump, what will happen if he brings a motion to dismiss before Judge Chutkan and then you got an appellate process? Will that case ever get tried before the November 5th election? I'm breathless. Take a listen on Legal AF. Let's move on to the Supreme Court oral argument and talk about 1512C of the U.S. codes, 18 U.S.C., and what it's all about. Let me put it in English. We've got a charge that was used by the Department of Justice and by the special counsel against Donald Trump, but particularly by the Department of Justice against more than 300 Jan 6 defendants. It was one of the highest charges that they used. If you put aside seditious conspiracy, which is at the highest level, the next highest level in terms of sentencing, years in prison that they were looking at, was the criminal obstruction of an official proceeding, the official proceeding being Congress's counting of the electoral certificates. I mean, there's no doubt, even in their own words, that many of the Jan 6 were there to try to strangle, kill, assassinate, or otherwise stop the counting. One guy who's actually the appellant or the defendant in the case that's up before the United States Supreme Court, Joe Fisher, a former police officer from Pennsylvania, he actually wrote on his social media, basically, Congressperson can't vote if he can't breathe. I mean, I don't know how much more interference with an official proceeding you can get than that. And he's the guy that brought the case. And his argument was a very arcane, picayune interpretation of this statute in the 2 sections of the statute. The statute was passed, we'll all agree to this. The statute was not passed to address insurrectionists trying to burn down the Capitol. Okay, we all agree to that. It was passed originally in the 2002 or so, after the Enron scandal, which was sort of the FTX of its day, where sort of a company that you thought had assets and you thought had an underlying business model actually was just a big Ponzi scheme and a fraud. And it went down, and it took Arthur Andersen, for those that follow big 3-4 accounting firms, which had been around for like 150 years, it took Arthur Andersen down with them. They're no longer here because they helped destroy evidence, including documents, which interfered with an official proceeding, which was the investigation. And so to make sure there was a crime on the books that actually fit those types of facts or future events, Congress passed, as part of Sarbanes-Oxley, a particular criminal statute that said, in effect, that if you alter, destroy, mutilate, hide, secrete evidence, documents, information, that definitely interferes with an official proceeding, which would be the investigation or a court proceeding or something of that nature, or otherwise criminally interfere with or impede an official proceeding. And the way the prosecutors decided that, because that's what you got to do, and Karen will give more detail about it, that's what you got to do as a prosecutor. You can't make up a new crime. Let's get a crime that exactly. You have to take the crimes that are on the books and then go methodically through them and figure out which of them you can map onto the conduct and not be accused of overcharging or have an ambiguity or some other infirmity that would allow the dismissal of the indictment or of that charge. And so they said, well, the second part of this, otherwise impedes an official proceeding. I think we all agree the congressional counting of votes is an official proceeding, and this is the otherwise. This is how they did it. They did it by hanging up gallows and battling medieval style with Capitol Police and Metro Police and trying to assassinate elected officials. And they did. They were successful in delaying that event. So we had an oral argument based on Joe Fisher's position that you have to have physical, something akin to ripping up the electoral ballots, the electoral certificates, in order for him to have been charged with that. And I thought, having read it and read the briefing around it, this would not be that difficult for the Supreme Court to reject that argument. But that's not how it played out. As far my count, I want to get yours next, Karen, is that it's teetering on a knife's edge. You've got Alito, Thomas, and Gorsuch, who are definitely don't think this law is being properly applied to these issues and thinks you got to have something akin to ripping up the ballots, the certificates, in order for this to happen. Then you got on the other extreme, you've got Ketanji Brown Jackson, definitely Kagan, and Sotomayor. So you got 3-3. Then you got Kavanaugh and Amy Coney Barrett, who didn't say much. And then, and by the way, Thomas didn't even show up for oral argument on Monday, but showed up for oral argument for this one. And then you got Roberts, who sort of spoke out of both sides of his mouth. At one point, I thought, well, he's definitely against the statute being used in this crime. And then he was trying, you could see him out loud, trying to find a way not to strike it down, which would lead to 300 Jan 6 defendants getting this stricken from their indictments, or maybe them being released and all of this other stuff. And then it has an impact on Donald Trump. Why don't you pick it up from what you picked up from the oral argument, pick up the Donald Trump part, I'll comment on that, and then we're a wrap.
Let me tell you something. This one makes me so mad. I can't even explain to you how much this pisses me off, because the statute could not be clearer, just couldn't be clearer. And to say, if the Supreme Court rules that this doesn't apply here, honestly, they're just looking for a reason to release the patriots, as Donald Trump likes to say, the Jan 6 people who are convicted of this. It is absolutely squarely in this statute. So much so, I actually read both the briefs in this, and I also listened to the oral arguments, and I went over the statute over and over and over again, because I don't get it. I don't get the defense argument, or whatever he is, the respondent. You know, it's always confusing who's who, but I don't get the argument from Mr. Fisher, the defendant. I don't understand it. I don't understand how Judge Nickel, who at the district court level literally contorted his reasoning to fit this, and the Supreme Court's going to take it and run with it. It makes no sense whatsoever. And the reason is there's, and I know you went over this, but I think it's worth talking about one more time, because I want people to really understand how absolutely, utterly, frankly, outside the law the Supreme Court can sometimes be. And this is going to be one of those times, in addition to Dobbs, you know, the case that overturned Roe versus Wade, if they do it here. This statute does have a section. There's two sections, Section 1 and Section 2. It's whoever corruptly, Section 1 says, as you said, rips up the papers, right? The documents and all that, the records, or other object. Okay, so not just papers, and you know, it encompasses other objects. It says or other object. Then there's section, then it says it ends, and then it says or, okay, doesn't have to be papers and records and documents or some other object, or otherwise obstructs, influences, or impedes any official proceeding. And when you look at the definition of official proceeding, a congressional proceeding counts. Okay, that's what it is. That's what the statute's all about. It's about a congressional proceeding. There is no statute that more squarely fits this. And they say, oh, it's never been used for a case like this before, because we've never had an insurrection before. We've never had a January 6th before. We've never had anyone try to stop Congress from certifying an election before. So yeah, it's never been used for that before. But I'm a prosecutor. I shouldn't say that. I used to be a prosecutor. I like to still think I am, apparently. I have interpreted many statutes. I've applied many statutes to conduct. And yes, every once in a while, someone commits a crime that doesn't look like other crimes that have been convicted or committed, I should say. And you look at the statutes that fit the crime. And that's what we have here. And it is so clear when they say, oh, well, it really has to be something physical. It has to be like a paper or whatever. Okay, that's in section 1. It says, or other records. It accounts for that. This second part isn't the or other records part. This is some other way. And no matter how many times you read their legal reasoning and read their arguments, it is just not the case. And it's just really pissed me off because it's like they're looking for a reason to overturn.
Then you hated Alito and Thomas because the argument, just so we don't lose sight of it, I don't like the argument. I think it's nonsensical under all the prevailing statutory interpretation methods that you use, but I understand the argument, which is the word otherwise somehow sucks in what is in section 1. I know. No, I'm not.
Honestly, you're smarter than me, Popok. Because
I'm not smarter than you.
You are. You know why? Because I actually, no matter how many times I read it, I don't understand it.
Well, then let me just put it up because I think we do a disservice if we don't at least explain the BS. But let me preface it by saying I totally agree with you. It's total BS, and I agree with Kagan. I did a hot take on this one, and I led with Kagan because I think Kagan did very well, as she usually does, in her surgical questioning of the lawyer for Joe Fisher. Again, and I'm going to reinforce a point you earlier made about they ignored the facts when it doesn't help them on the Supreme Court, and they want to make new law in an activist way. And they have here because the appellant here, who's the Joe Fisher, the set of facts is terrible. But they just ignore the facts because they want to get into the statute, which is not what they're supposed to be doing. It's like an advisory opinion then. But I don't agree with the interpretation. I agree with you. But the argument is that the word otherwise coming so close in time and the way you interpret to the prior list of things has to be like the list of things or similar to it as the sort of hinge between section 1 and section 2 of the statute. I think it's a terrible argument, but Roberts, who's I think is the swing vote here, because if it's going to, I think this is 5-4, and it's Roberts probably making it's 5-4 if I'm right that Kavanaugh and Amy Coney Barrett sort of slide over because it makes terrible precedent, terrible law, and they get into and they side with that. But Roberts at one point said, I don't like the overbreadth of this. I don't know if he used the word dragnet or it was Gorsuch, but they saw it as sort of a dragnet as opposed to a catch-all, which is what the Solicitor General, Liz Proliger, was arguing. This is a catch-all. Congress did it on purpose. What you said, Karen, this list of things of destruction and impeding objects and this and that, and then a non-destruction of things provision at the bottom of it. So it's Roberts going to have to find a way to kind of thread this needle to keep this thing alive. Let me switch quickly to, before we end the podcast, let me switch quickly to what it means for Trump. Because very, very smartly anticipating all of these arguments and wherever they arise, the special counsel's office in its briefing told the Supreme Court in immunity, which is being argued on the 25th, that even because they know that this was up before them at the same time or about around the same time, they said, even if you were to somehow find that those charges were wrong against those defendants who definitely didn't come near, thank God, because Capitol Police and Metro Police were heroes that day and kept them out of the chamber. Well, at least while the counting was going on, they didn't get their dirty little grubby hands on these certificates. That's not the case for Donald Trump. Donald Trump is alleged in his indictment to be a part and leader of an orchestrated conspiracy that involved fake documents, i.e. the fake elector certificates, which would be a document that clearly fits within number sub 1 of the statute. So he does have false, fraudulent, forged documents to impede an official proceeding, because that was supposed to gum up the works. So special counsel Jack Smith said, we have an outlet, even if you were to dismiss it for Joe Fisher and those like him, it would not apply to Donald Trump because we firmly fit within sub 1 of the statute. But having said that, that doesn't mean that Todd Blanche and John Sauro, Lauro, whatever his name is, the lawyers for Donald Trump in the DC election interference case, don't immediately, when that case gets back up and running, we hope, file a motion to dismiss based on the Supreme Court precedent of Fisher versus U.S. Chutkan's going to have full briefing on it. They'll make the arguments on the prosecution side that we're making here, but she's going to have to hear full argument. The loser is going to take an appeal, and there goes. And that this is Donald Trump's, what he's wanted all along. There goes the DC election interference case before the November 5th election. Welcome back. That was Legal AF. A little calmer, a little less exasperated, but you get the idea. We do a show. It's called Legal AF. Join us on Wednesdays and Saturdays on 8 p.m. on this YouTube channel for MeidasTouch. You'll find out why we call it Legal AF. I think you can sort of figure it out. We pull together and curate the top 5 developments at the intersection of law and politics. We bring it to you right here, and then on audio podcast platforms, Legal AF. Just look us up. If you know about Legal AF and you've already maybe seen the episode or you missed the clip, there it is. You can also use it. You can be part of our ad hoc marketing department. We don't have one. We're building the network from scratch. Take that clip, send it off to friends and family, and say, hey, you know that show, Legal AF, I like? Take a listen. Maybe they'll join our audience. If you have no idea what I'm talking about, that was Legal AF. I'm Michael Popok, and join us on Wednesdays and Saturdays at 8 p.m. Eastern Time. So until my next hot take, until my next Legal AF, until my next Patreon exclusive content, this is Michael Popok reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.